So we are at the third day of Tokyo International Law Seminar, and allow me to introduce the lecturer of our first morning session today. We have with us Professor Mohamed HELAL, and he is a professor with Ohio State University and also a diplomat serving at the United Nations and international civil servant with the African Union. The topic of his lecture today is international law applicable to the cyberspace. Thank you.
Well, thank you very much. Good morning, everyone. So obviously, I'd like to start off by thanking all of you. I'd like to thank Director General Nakamura and my dear friend, Ambassador Tomohiro Mikanagi, for the invitation. All of you in the legal department of the Foreign Ministry of Japan for the phenomenal work that you're doing in organizing this remarkable seminar. So thank you very much. All right, so the topic of today's lecture is the application of international law in cyberspace. All right? And my talk is basically divided into two parts. We're going to start off with a series of hypotheticals about how international law applies to and regulates the conduct of states in cyberspace. And then the second part, we're going to go through the views expressed by states on the scope and content of the rules of international law that apply in cyberspace. Those views, as you're going to see in the second part of my talk, have been expressed in a series of national and regional positions that have been issued by governments pretty much in the past 5 to 10 years. So basically, in the past 5 to 10 years, several governments, around 40, have issued position papers in which they outline their views on how international law applies to cyberspace and how it regulates the conduct of states in cyberspace. So we're going to look at what states have said about the rules of international law that apply in cyberspace through these position papers. But before we go into the substance of the talk, if there's one thing I'm hoping you will take away from this talk, it's this. In my view, this conversation, the debate that is ongoing internationally on how international law applies to and regulates state conduct in cyberspace, is perhaps the most important debate in international law today. And the reason I say that is because I think this conversation is reshaping international law. And it's reshaping international law in two ways. As you're going to see, this is a debate that is reconfiguring many of the fundamental rules of international law. The basic building blocks of international law are being reshaped, reconfigured, and reimagined in this conversation. As you're going to see in part 2 of this lecture, rules such as the prohibition on the use of force, a peremptory rule of international law, rules such as the prohibition on intervention in the internal and external affairs of states, virtually every rule of international humanitarian law, including the laws of the conduct of hostilities, the concept of due diligence, rules of human rights, and secondary rules, such as rules relating to attribution, necessity, countermeasures, and so on and so forth. All of these rules are being reshaped and reconfigured as part of this debate. Moreover, there are methodological implications in this debate. In other words, the way that international law gets changed, the methodology of making international law is also being affected by this debate. For instance, we all know there are two elements in customary international law: opinio juris and state practice. But what counts as state practice? Can the secret conduct of states count as state practice? Can you have state practice without public expressions of opinio juris can that create or alter the content of customary international law? How do we interpret treaties through the conduct of states? What counts as subsequent practice? What counts as subsequent agreements? How do we determine the object and purpose of treaties, and how do we interpret them? All of these methodological questions are also implicated in this conversation. So that's really the main thing that I hope you will take away from this lecture. So you can go to sleep now, if you can switch off. But really, I hope that you will take away from this lecture that this topic is important. I hope that you will go back to your governments and brief your political superiors or your director generals about this debate, and to emphasize the importance of your countries engaging in this conversation, because it really is reconfiguring all of international law. All right? So this is the main takeaway from this conversation. And to give you a sense of how this debate, how the question of international law and cyberspace is affecting international law, we're going to start off with a series of hypotheticals. How many of you are familiar with Lord of the Rings? Raise your hands. All right, so you should recognize these hypothetical countries. All right, Rohan and Gondor, they are countries that are from the Lord of the Rings. So these are two hypothetical countries that we're going to use so that we don't step on anyone's toes. Right? It's better to use fictional countries. All right, so we've got these two countries. All right? So let's start going through these hypotheticals. So we have Madam Ambassador here. She is the ambassador of Rohan, accredited to Gondor. So let's go through these four possible situations that any ambassador may encounter in their work. So you have a citizen who has been arrested. So a citizen of Rohan is arrested in Gondor, and the ambassador goes to the foreign ministry and asks for a consular visit. Lawful or unlawful? Does this break international law? What do you all think? Yes? No? What do you think? If an ambassador asks to visit their citizen who has been arrested, is that unlawful? You're shaking your head. Why not?
Part of the standard functions of an ambassador of state.
Exactly. Not only is it not unlawful, it's actually permitted. Article 36 of the Vienna Convention on Consular Relations explicitly says that as part of your consular functions is to conduct consular visits. Which means if an ambassador asks a foreign government to do this, they're perfectly within their rights. All right, let's move a step further. Let's assume, and I apologize, I'm going to use Ambassador Mikanagi as an example. Let's assume my good friend Ambassador Mikanagi, he's the Deputy Permanent Representative of Japan to the United Nations. Let's assume he gives me a call one day, and he says, look, we have excellent relations between our two countries. We have excellent relations between our two missions. Japan would be greatly appreciative. Japan would be grateful if you vote in a particular way on a resolution in the General Assembly. Lawful or unlawful? What's that? Lawful. How many of you say lawful? Vote. This is going to be a very democratic lecture. But we don't have unanimity. Some of you are not raising your hands. Those of you who have not raised your hands, do you think it's unlawful? Does anybody think it's unlawful? But, sorry? The girlfriend? No, my counterpart in the mission of Japan is asking me, is basically trying to lobby for a vote in the United Nations. No, not unlawful. Okay. Yeah, it's fine, right? Okay, now let's go a step further. Let's assume that our friend here, the ambassador, she's the ambassador of Rohan, and Gondor has an election. And then the ambassador says, the government of Rohan supports this particular candidate in an election. Or the ambassador of Rohan says, we support a particular result in a referendum. So let's imagine that Gondor is in an organization called the Union of Middle Earth. And they are having a referendum on whether or not to stay. Let's call it Gondor exit. And the ambassador says, we support that you exit this union. Lawful or unlawful? How many of you think it is lawful? Okay, we have less hands. How many of you think it is unlawful? If you're unsure, that's fine. All right, so I'm going to call on you. Why?
Interference with internal affairs.
Good. Where is this rule, though? Where? So,
The UN Charter.
no, it's not in the UN Charter. Where in the UN Charter?
Like the sovereignty of the country.
Okay, so wait. So these are two different rules. Is it sovereignty or non-intervention?
Both of them. Like sovereignty
Both of
from the country who's conducting election.
Excellent.
And interference from
Yes.
the country of the ambassador.
Super. Google the UN Charter. Open it right now. Can you point to the article that says sovereignty is a rule of international law? And point to the article that says non-intervention is a rule of international law. I'll give you 5 yens. Is that a lot of money? I don't know if that's a lot of money. Okay, good. So I'm not committing to too much. Can anybody find in the UN Charter the rule that says that sovereignty is a rule of international law or that non-intervention is a rule of international law? Because those are the two rules that our friend from Uzbekistan has cited. 1, 2. Exactly. Well, right. Thank you. But see, Socrates never gives answers. He just asks questions and lets you all. That would make me Plato. But the answer is the United Nations Charter does not include a rule of sovereignty. Article 2, paragraph 1 speaks of sovereign equality. And that's not the same thing as sovereignty per se. Sovereign equality essentially means that all states are equal before the law. But there's no definition of sovereignty per se in the UN Charter. Second, non-intervention may appear to be in Article 2, paragraph 7, but it's not. Article 2, paragraph 7 of the UN Charter addresses the United Nations. It doesn't address other countries. It basically says that the United Nations, as a person of international law, shall not intervene in the internal affairs of states unless it is taking enforcement action to protect international peace and security. So actually, Article 2, paragraph 7 does not address states. It's not designed to speak to states. So we go back. Is this unlawful or lawful? And let me ask you a more let's add an element to this question. How do you distinguish between the second hypothetical and the third hypothetical? When we asked about a vote in the UN, you were all like, no, of course it's lawful. Of course it's lawful. And I agree. But why is it okay for one government to tell another government how to vote at the UN, or at least to encourage it to vote in a particular way, but it is not okay to express a position on the domestic politics or the foreign policy choices, such as a result in a referendum? Why is that not okay? Can you provide a juridical answer to that? Yes? You're going to do a lot of running today, my friend.
In the Vienna Convention.
Yes. Which one? There's many of those.
On diplomatic relations.
Perfect.
Ambassadors are forbidden to interfere in the internal affairs of
Correct.
states.
Which provision?
I don't remember.
41, paragraph 1.
I forgot all my files.
It's 41 paragraph 1, 41.1. But here's the interesting part. That provision says it prohibits, it says non-interference in the internal affairs of states, internal. So maybe that covers the candidate in an election. But if a country is taking a position on membership in an international organization, is that internal or external? Could be internal, right? So wonderful. So what you have identified is the principal applicable rule in this matter. That is the principal applicable rule. Look, the main takeaway from this, as you'll see in a moment, is that the content of each of the rules that you have identified is being reshaped, reconfigured, and changed because of the discussion on cyberspace. And that's what you will see in a moment. All right, last hypothetical on this slide. Let's assume Madam Ambassador here marches into the foreign ministry of Gondor and says, turn over those islands that we believe belong to us. And if you don't, we're going to invade you. It's an ultimatum. Okay? Lawful or unlawful? Who thinks it's unlawful? You've got to be more enthusiastic than that.
I don't think it's unlawful.
Sorry?
I said, because you can't force an opinion on another state because it would infringe the sovereignty in terms of making decisions.
Perfect. What is the applicable rule, though? What rule of international law is such conduct breaching?
Not sure.
Anyone? Again, country A walks to country B and says, turn over that territory, or else we're going to invade you. Threat or the use of force. Where is that found? Paragraph 4, Article 2 of the UN Charter. It's also an established rule of customary international law and a peremptory rule of international law. So what you're starting to see here is a spectrum. Some forms of conduct are not only lawful, but permissible. Like there's an actual permission. Consular visits. Lobbying a vote is generally considered not unlawful because it's part of the conduct of diplomacy. Expressing support for a candidate, it's more gray. It's more gray. Most scholars would say it probably violates Article 41, Paragraph 1 of the Vienna Convention on Diplomatic Relations, which prohibits intervention in the internal affairs of states. But again, it's debatable. I don't want to point to any particular country or any particular situation, but in the past 10 years, we have had many examples of countries saying, we think this candidate would be better. We think this outcome in a referendum would be better. And interestingly, many countries do not object to that conduct. So that's why I'm saying it's sort of gray. But an ultimatum, everybody agrees. Okay? Now, let's turn this into cyberspace. All right, so everything I told you, all of these hypotheticals are in the kinetic world, they're in the physical world. But let's do the same kind of conduct in cyberspace. Let's assume a country has an election coming up, or a referendum coming up. And so Gondor has an election. And then Rohan launches a campaign online, on social media, on WhatsApp, that has disinformation and deep fakes. What do you think about that? Lawful or unlawful? How many of you think it is lawful? How many of you think it is okay for country A to design and launch a campaign using misinformation, deep fakes, misinformation, chatbots, all of those kinds of instruments to sway an election? How many of you think it is lawful? It's not a violation of international law. Raise your hands. How many of you think it is a violation of international law? How many of you think it's unlawful? Okay. Why? Why, Ms. Sarah? Here, right here. I'm so sorry. You're going to get your exercise in today.
Interference in a sovereign state,
But
in
why?
the affairs of the sovereign
Yes.
state.
Why? Why compared to number 3? Are these different or are they the same? Basically, the question is this. When I asked number 3, there was some hesitance in the room. Some people were saying, this is a ballpark. Maybe 60% said, we're not sure, maybe lawful, maybe unlawful. But here, in the room, there seemed to be more clarity and more certainty that this was unlawful. My question to all of you is, why? What is the difference between the two cases? Yes, here. Here, okay.
Well, I don't know exactly, but if we rethink the concept of territory of the country and we include cyberspace into the territory of the country, in this case, one country directly enters to the territory of another country.
Okay, I see. So what you're saying is, but remember, here, the ambassador...
Just express the information.
Okay, so what happens, so what you're saying is because with cyberspace, you're entering the territory.
Yes.
Okay, what happens if, all of these campaigns are managed from abroad?
That's why I'm saying I'm not sure.
You're not
but
sure.
if we rethink the concept of territory.
Yeah.
But to do this, we have to
Say that again. Say that again slowly.
rethink the concept of the territory.
Think about that for a moment. That's exactly right. Our entire conception of international law, and in fact international politics, is anchored in territory. The debate on cyberspace is pushing us to rethink fundamental notions like territory. What is the value and effect of territoriality if so much of our lives is dependent on a domain that is inherently deterritorialized? That is how fundamental this conversation is. Maybe territory doesn't matter anymore. Think of 100, 200, 300 years ago. Countries went to war with each other over natural resources, right? Partially why we had that institution called colonialism. But now, what is an incredibly valuable resource? Data. It's deterritorialized. So one of the major takeaways here, this conversation is not only forcing us to rethink about rules of international law, it is challenging the very foundation of the international legal and political system that we have inherited and that has existed really since time immemorial. So anyway, the short of it here is this is a hard case. For some scholars, for some countries, there is no difference between a spokesperson in a foreign ministry expressing a view, issuing a statement on the internal politics of another country, versus a disinformation campaign. For some scholars, they're the same. For other scholars, for other countries, there is a fundamental difference. But what we are seeing is there's a difficulty in transforming these differences into clear legal concepts and legal rules. And part of it because this technology is new. Many of these practices are new. All right, next hypothetical. Rohan launches this aircraft into the territory of Gondor to take pictures. All right? Surveillance. All right? Flying over the territory of another country, taking pictures. What is this called? It's called surveillance. It's intelligence gathering, right? Okay. Lawful or unlawful? How many of you think it's unlawful or lawful? Go ahead. Sorry? Look, I'll get you lunch. I'm so sorry. You're moving around. Yeah.
It is unlawful, is a violation of the territorial sovereignty of a state.
Okay, again, where is this rule? So again, if there's another thing you take away from here, in your memos, in your writing, in your argumentation, always anchor your conclusions in a specific rule. Where is the provision? What rule of customary international law is being violated?
Well, I think there are some rules about it under the ICAO organization.
Perfect. Exactly. So the 1944 Chicago Convention, Article 3, Paragraph C, says that state aircraft shall not fly over the territory of a foreign state without authorization. But you also, so this is, what is this called? This is a lex specialis rule, right? It's a lex specialis rule. But you also mentioned sovereignty. And we sort of go back to that original question from the first hypothetical, but what exactly is sovereignty? Where is it written in international law? It's not in the charter. It's not in the charter. Some of you are going to say it's a customary rule. You're probably right. But what is its scope and content? What is the content of sovereignty? Those are questions that are being discussed in this conversation. All right, so generally, the consensus among scholars and state practice that if you send an airplane over your territory taking pictures, unlawful. But that's the old news. That's the old world. That's like the 20th century. In the 21st century, nobody needs to do that anymore. They will send malware, a virus, a backdoor, a computer program that can be lodged in your cyber infrastructure and in a way to take pictures, to exfiltrate information. Lawful or unlawful? What do y'all think? All right, let's vote. How many of you think it is lawful? And, okay, I should say, Chatham House rules. So let's say this. If you raise your hand and say it's lawful, it does not necessarily mean your country is doing this. All right? So we take that off the table. How many of you think it is lawful? Is that a hand or is that? Okay, go ahead.
What is not prohibited, it's not regulated, it's okay.
Brilliant. Where is that rule from? You just cited the most important case in international law, the SS Lotus case. What is not prohibited is permitted. It's a core axiom of international law. Excellent point. You know why? Because there's nowhere in international law where you have a positive rule that says espionage is unlawful. You don't have a rule like that. But here is my question. Why is this unlawful, but this is, if not lawful, at least not prohibited? What is the difference between these two scenarios?
No difference.
But you just said.
I didn't say that this is unlawful.
Oh, perfect. So you say it's lawful.
Yeah, it's okay.
It's okay. Okay, perfect. Okay, that's great. That's consistency. But the challenge here is that for virtually all countries, this is unlawful. But here, there's a question mark. We don't know what to do. We're unsure. Countries are saying, wait, there's no rule against espionage. And remember what you said about territoriality? This idea of territoriality in cyberspace and intercepting data as it moves through countries and routers and systems, that's really not, it's a deterritorialized activity. And so, we don't know if this is lawful or unlawful. Again, I'm giving you these examples to show you why this debate is important. We're not only talking about the regulation of cyberspace, which is so important to all of your lives. Look at you. All of you have cyberspace in your hands right now. In your computers, in your phones. It's these people who wear Oura rings. Do you know about that? People are virtually having them in their hands, and the next step, they'll put chips in your fingers. But anyway, that's a different conversation. You see what I'm saying? These are the stakes. That's why this debate is important. All right, last set of hypotheticals. LOAC, Laws of Armed Conflict. First hypothetical, an artillery attack against a hospital. This is a really easy one. Lawful or unlawful? Can you attack a hospital during an armed conflict? No. Why not?
Yeah, it is against the humanitarian law.
Exactly. There are so many rules in international humanitarian law that prohibit the targeting of civilian objects, right? And hospitals are generally considered civilian objects. So what are the applicable rules? You have Article 18 of the Fourth Geneva Convention, you have Article 27 of the 1907 Hague Regulations, and then you have a set of rules from the 1977 First Additional Protocol. For example, Article 48 and 49 and 50, 52, and 57 define what you can and cannot target. They define proportionality. They define attack. They define what counts as a civilian object and what counts as a military objective. So we have the rules, they're written down. But think of the world in which these rules were written. These rules were written in 1907, in 1949, and 1977. They were, so like for us diplomats, they were sending cables and maybe like Morse code. It feels like it's ancient history. So basically, these rules were written at a time when war was primarily conducted through physical violence. And the rules were designed around that fundamental foundation, is that we're trying to limit what you can and cannot do through physical violence in warfare. But now things are changing. So let's do the next one. An airstrike. So we did artillery on a hospital. Airstrike on a bridge. Lawful or unlawful? The answer, by the way, is the best answer that any lawyer can give. Take a step back. Yes, you said it. What is it? No, you got to say it. Too late. Perfect. That is the best answer. Whenever your boss asks you a question, if you don't know, your first answer is depends. Depends. I'll get back to you. It's very complicated. It depends. Why does it depend? Perfect. So the question here is this. Is this object a civilian object or is it a military objective? And the definition of a military objective is provided in the First Additional Protocol. It is something that by its nature, location, purpose, or use makes an effective contribution to the conduct of operations. So it depends. You have to determine case by case whether taking out, bombing this bridge will make a contribution to your military objectives. Therefore, it depends. Okay, now let's sort of move to the 21st century. Airstrike, yes. Yes, on the bridge, yes.
Yes, sorry, I have
It's almost the title of a novel, Question on a Bridge.
Yes,
Go
I
ahead.
have a question on the bridge. Supposing the bridge is part of cultural heritage, but it is being as well used by the opponent for military purposes.
Of course, there are so many different, let's call them sort of special rules within the system of the laws of armed conflict. So if it's so for example, if it is a cultural object, if it is an object containing what are called dangerous forces, and so on and so forth. So you have special rules that would attach to special objects. For example, objects indispensable to the survival of the civilian population is another category. So you're absolutely right. We do have special categories that apply to certain objects. In my mind, this is just a generic bridge from A to B. But still, the answer would be it depends. All right, 21st century. Airstrike on a data center. Yeah, over here. You have to give him a raise. Good.
I think it also depends on the objective.
You're exactly right. You know what? The answer to this hypothetical is identical to the one before it. Whether it's a data center or a bridge ultimately doesn't matter. Because you have to ask, is it a civilian object? Is it a military objective? Does it make an effective contribution to the conduct of hostilities or not? And then let's assume it does, and you bomb it, you have to apply the rules in Article 52 and 57 of the first additional protocol that relate to proportionality, to make sure that you don't cause incidental loss of life or incidental damage to civilian objects that is disproportionate to the military objective. So the short answer is this. The rules of humanitarian law haven't really changed whether it's a physical object like a bridge or a physical object like a data center. The reason these two cases are the same is this. Because the nature of the effect is physical. Okay? Remember what I said a moment ago? That all of humanitarian law, the rules on the conduct of hostilities were designed to regulate physical violence. Now let's move to the brave new world. Let's assume you have an attack, an operation that has no physical effects, like disabling a military radar. How would you categorize that? And specifically, is it an attack? Is it an attack? What is the definition of an attack under international humanitarian law? It is an act of violence. Is it violence to send a virus to disable a radar? Is it an attack? Let's vote. Huh? Who said yes?
Physical effect.
Yes. But how do you reconcile that with the definition of Article 49, which is considered reflective of customary international? I'm talking about Article 49 of the first additional protocol of 1977, which defines an attack.
Can you repeat again the definition of attack?
An attack is an act of violence.
See, the violence sometimes has no effect.
Very interesting.
I mean, if it is not physical.
Very interesting. Violence sometimes has, you said no effects. No physical effects. That's very interesting. Very interesting. So there's a debate right now that touches exactly on this question. Should we define attacks exclusively in terms of operations, the effects of which have physical manifestations? Right? In other words, the traditional understanding is that it is an operation that causes death or injury to individuals or damage or destruction to objects. So one theory is that we should include operations that cause neutralization. Neutralization basically to render ineffective, regardless of physical effects. All right? That's one way of... Go ahead.
Sometimes the cyber attack, for example, it may lead to physical effect at the end.
Perfect. Hold on to that. Not the mic, the idea. Hold on to and the mic, actually. Hold on to both. Here's the issue. That's a great point. Under Article 52 of the additional protocol, it tells you that when conducting an attack, you have to take into consideration the potential for total or partial destruction, death, blah, blah, and neutralization. Putting aside whether it causes additional effects that are physical. This is one of the debates that is ongoing. What is the definition of an attack? What is the definition of an effect? Now, let's move to the last hypothetical, which is sort of what you're talking about. Now, let's assume the operation is not aimed at a military objective. It's just aimed at data. Like what? Can you give me an example of data that is stored anywhere?
For example, where are the military targets or defense targets that the country uses? Or some intelligence or some of its objects?
Yeah, but you're thinking like a lawyer. Think like a normal human being. Where is data? What is data? Where is it? Well, not exactly. The internet is just like, it's a network. Where do you have Facebook? Okay. Do you have pictures on Facebook?
Yes.
That's data.
Yes.
Okay. What else? How many of your governments have a database of treaties that you are party to? Data. That's data. It's stored on the cloud. By the way, the cloud is not in the cloud, right? You know, the cloud is actually a building, probably somewhere in Finland. You know what I mean? So, data. Not military data, not a military object like a military radar. Normal data, emails, information, pictures, Instagram, whatever. So the debate here is this. If you attack data, is data an object or not? Because traditionally, and this is the difference between this scenario and this scenario, because at least a military radar, you can actually see it. It is somewhere, and it usually has this thing that goes around, right? It's a physical object, but you are trying to neutralize a physical object. So there is material in international humanitarian law that you can use to apply to that case. But data is completely not physical. Is that an attack? Again, think of how these rules were designed. And remember what I said earlier about that this debate is also affecting how we make international law? Article 31 of the Vienna Convention on the Law of Treaties talks about interpreting treaties in accordance with their text and context and object and purpose. How do you apply these rules to reinterpreting the rules of the law of armed conflict to fit these new types of operations? These are the questions we're dealing with. All right? And in this area, the core question is data an object? Because for years, we thought data was physical object. But now, we're in a different world. So, basically, the main takeaway of all this is this debate is super important because it's changing fundamental rules of international law. We have to redefine sovereignty, or at least we have to interrogate the scope and content and juridical nature of sovereignty. We have to re-understand what the prohibition on intervention means. What exactly does it protect? What does it permit? We are being invited to rethink the prohibition on the use of force. Again, a peremptory rule of international law. Since the entry into force of the UN Charter, the definition of force in Article 2, Paragraph 4 has generally been stable. It's causing physical damage. That is what is protected. That is what is prohibited. But now we're entering into a world where country A can inflict damage on country B that is non-physical. How would you all survive without your phones for 1 hour? It has become a vital part of our lives, a vital part of every aspect of the function of governments. And the same thing with humanitarian law. So basically for the next sort of 50 minutes, we're going to try to go through these rules. And again, this is just a selection. We could have done human rights. We could have done due diligence. We could have done the peaceful settlement of disputes. We could have talked about human rights. We could have talked about countermeasures, individual or collective. We could have talked about necessity. We could have talked about attribution. The entire structure, system of international law is being renegotiated. And that is the core message of this talk. All right, let's start at the top. Sovereignty. Well, no, let me stop. Any questions? Also, so that I can take a drink. Good. Sovereignty.
Oh, sorry, Professor.
Yes, where?
Here.
Where? Yes. You know, your voice is just coming from up there like it's the voice of the Almighty. Go ahead.
Sorry to interrupt. I have a question, and my question is, how can we prove these cyber facts in the courts? And I'm afraid I'm not good at ITs, but are we going to call the expert witness? And would it be realistic to meet the standard of proof in the court?
So yeah, you're asking a question. So I have two answers for you. In the context of state-to-state operations, we don't have a lot of litigation. But the short answer is you engage in what is called forensic cyber investigation. All right? So think about it this way. If your computer is hacked, what do? I have no idea about Japanese law. But if you're in Japan and your computer is hacked and somebody steals your email or does what is called ransomware, which means they lock you out of your computer and they say, pay me 1,000 yen. I understand that's very little money. But pay me some money so that I can release your computer. What do? Where do you go? I'm assuming you go to the police and you have a cyber investigations unit, some kind of a unit that engages in forensic investigations in the area of cyberspace. And that's primarily in the area of cyber crime. All right? Think of bank fraud. So we have the technology. But your question, this is sort of the second part of my answer, there's one layer of the question that relates to gathering the material evidence. But there's a much more complex question of law that relates to attribution. Remember yesterday's slide from Professor Webb's presentation where she presented how there is spying using programs like Pegasus? These programs operate through the networks and systems of so many countries. So the challenge often is how do you attribute, as a matter of law, conduct to a state. All right? But the technology exists for tracing wrongful conduct. But of course, it exists. Some countries have many more resources than other countries. All right? So the technology does exist, but there are very difficult questions of law that continue to be unanswered. All right? So let's go back to sovereignty. What is sovereignty? What is sovereignty? Can anybody define sovereignty? Where? Yes.
Sovereignty means keeping the state respected. It's like, sorry if I said entity, respected entity, and its organizations and people belonging to it.
So sovereignty is respect.
It's something supreme, something higher than respect. It's to maintain the whole stability or the whole. I'm searching for the right word. Integrity, maybe.
So you've offered me three words: integrity, respect, and supreme, something like that.
Yes, yes.
So we have three possible words. What else? Yeah, go ahead.
I think sovereignty is freedom, is power. It's the power that has been conferred. It's the power that has been conferred to the state by the international recognition. However, we were talking about the fact, and I think I can confirm, yes, Professor, you are absolutely right. I think sovereignty has not been defined in the way that we wish it would have been. However, states define where the territory extends, and in the national laws, each state defines what is the territory and what is allowed and not allowed for other states to do in their territory, and that provides a demarcation onto the freedom of the other states over that particular state.
Okay.
Thank you.
No, thank you. So we have respect, integrity, supremacy, freedom, recognition, power. These are all terms that are being used to describe sovereignty. And then you invoked domestic law as maybe material that we could use to understand sovereignty. But of course, you all know, we can't really invoke domestic law directly in international law. Maybe it could be used as evidence of state practice for the purpose of generating custom, maybe, possibly, in certain ways. But I mean, folks, this is considered the cornerstone of international law, and we seem to be struggling to define it. Yes, go ahead.
I would also define sovereignty as power.
Power.
Yeah, power beyond reach of external interference.
Okay. Yes, sorry, go ahead. Power beyond the reach of external interference. Hold on to that. Yes.
I think my idea is a little bit similar to the lady mentioned before. There is this general types of thinking to think the internal sovereignty and the external sovereignty. For the internal sovereignty, it usually refers to the supreme authority within its own territory. And for the external sovereignty, it usually refers to the independence from the control of other states or other higher power outside of the territory.
Brilliant. Is she with you? Is she in your office?
No, I am currently a PhD student at the University of Tokyo.
Obviously. That's a PhD answer. You should get your PhD today. Yes. I disagree with you, but you should get your PhD today. Yes.
Thank you, Prof. For me, I would also define sovereignty as independence
yes.
and self-determination.
Oh, yes, my brother. This is the African answer. Excellent. If you haven't been to Uganda, you have to go to the Speak Resort in Mignogno. Okay. So we have the following: respect, integrity, supremacy, integrity, recognition, power, but then power without interference. Then we have a wonderful answer about dividing sovereignty into internal and external aspects. And you have your thing the way around. Ramdan is basically saying it's also independence and self-determination. Here's the challenge. None of these options are codified anywhere. What you basically cited probably comes from Oppenheim, right? It's probably a textbook that defined sovereignty in terms of supremacy and then divided supremacy into two forms of supremacy, internal and external. That's one way. Independence. So many of you refer to independence. To me, that's substituting one ambiguous word for another. Because now I ask you, what is independence? What does it mean to be independent? And let me ask you, actually, is there any country that is really totally independent? What does it mean to be independent? What does it mean? What is independence? Somebody, and if you say freedom, I'm going to ask you then, what's freedom? Yes?
Yes, I think independent also refers to the position of a certain state or country not being in a specific military alliance.
Wait, Article, no, I'm not going to pick on Japan. Article, how many countries are in alliances? Are you suggesting that all the members of the North Atlantic Treaty Organization are not independent?
I'm saying that the independency of certain countries may have different interpretation of what constitutes sovereignty itself.
Okay, so we don't have one common understanding of independence?
As of now, probably yes.
Okay. You can't say it depends, though.
I mean, it's an exercise of sovereignty to join an alliance. It's an exercise.
SS Wimbledon.
I mean, the clue is in the word, sovereign.
Yes.
We go back hundreds of years to the king who said, that wall and that wall, everything in between is mine. That river to that river is mine.
Yes.
And all those who are here share this land together.
You're exactly right. So there was a question one time before the Permanent Court of Arbitration, and the question was, it was the customs union case, and there was a question of whether Austria is still a sovereign state because it entered into a customs union with Germany, and the part of the response of the court, well, entering into a treaty, let's call it this, in this case it was customs, but it could be an alliance. Japan is an alliance, a mutual defense pact with the United States. Does that mean Japan is not independent? Of course not. Because entry into international engagements, whether in the form of law or political engagement or not, is actually an exercise of sovereignty. So, but what you're giving me is manifestations of sovereignty, as opposed to defining the thing itself. This is the challenge, folks. This conversation in cyberspace is This conversation in cyberspace has led countries to adopt varying views on the meaning of sovereignty. And again, I'm going to stop here for like 3 seconds. Let that sink. Let that sink for a second. We are in 2025, and you know, I hate it when international law textbooks start with the Peace of Westphalia. It is a myth. Okay, the Peace of Westphalia did not invent the state, it didn't invent sovereignty. I'm sorry to break it to you, that's historically completely inaccurate. All these books are wrong. You've been defrauded. But the idea here is this. The concept that all of us lawyers thought was the cornerstone of the entire field is being reconsidered. And let me show you how. At the moment, we have 3 approaches to understanding sovereignty. And notice, these approaches are not limited to cyberspace. This is so important. What I'm going to talk to you now about is the positions adopted by these countries or organizations on sovereignty. Remember what I told you earlier, that these positions appear in national positions on the application of international law in cyberspace or common regional positions. But if you look at these documents, you will see that those countries or organizations are not limiting their views to sovereignty in cyberspace. They're talking sovereignty lex generalis, as it applies generally. So what are these views? We have a spectrum. On one side of the spectrum is the United Kingdom, which says sovereignty is a concept. It is a notion from which primary rules of international law could be extrapolated, but it is not a primary rule of international law. Just to make sure, does everybody know what I mean when I say primary rule versus secondary rule, or do we need to do a little detour into jurisprudence? Are we all okay? And it's perfectly fine. This is why we're here, to work together. Does anybody not know the distinction between primary and secondary? Because it's super important. It's okay, tell me if you don't. Do we all know the difference? All right, you got your chance. So the United Kingdom tells us that sovereignty is not a primary rule of international law, which means you cannot violate sovereignty. Think about it. A primary rule is a rule that generates obligations for states. It tells states what to do or what not to do. Thou shalt not torture. Thou shalt not violate the political independence and integrity of states. Thou shalt not threaten the use of force. If you're a member of the WTO, thou shalt not impose unilateral tariffs on other countries. These are rules. They're called primary rules. The UK position is sovereignty is not a primary rule, which means you can't violate it. Because it's not there. It doesn't tell you anything. It doesn't, in more technical terms, it neither prescribes or proscribes any conduct. That's the UK position. Then we have a middle position, which includes these countries and organizations. The EU is there as well. These countries and organizations basically say the following. Sovereignty is a primary rule of international law. But the way that sovereignty applies in cyberspace is peculiar. And here's how. Those countries basically say the following. In order to violate sovereignty, a cyber operation needs to cross a minimum threshold of harm. Minimum threshold of harm. Remember our hypothetical from like 30 minutes ago about the airplane and the malware? What is the harm that happens when an airplane crosses into the airspace of another country? Really, there's no physical harm. It's just a plane crossing in the airspace. There's no real physical harm. There's no harm that manifests. You can't touch it. You can't point to it. It's a juridical harm. It's a conceptual harm. You crossed into my sphere of supremacy, right? I am supreme on this territory. Don't cross into it, even if there's no actual harm. So what these countries tell you is the following. In order to violate international law, there is a threshold of harm that must be crossed. But if you have a cyber operation that is below that threshold, it is not illegal. It is not illegal. So that's the middle position. And it's middle because it recognizes that there is something called sovereignty as a primary rule, but it creates what you can call a caveat. It's a caveat. It says sovereignty in cyberspace operates in a different way. If you have an operation that does not cause harm, it's not prohibited by sovereignty. And then you have, at the other end of the spectrum, views expressed by the African Union, France, China, Brazil. And I have to tell you, you are sitting here with international law royalty because my friend Messeret here had a central role in the writing of the Common African Position on International Law and Cyberspace. Here, you can hold that up. I know, I'm sure you do. All right? So these actors, these countries and the AU, basically say the following. Sovereignty is a primary rule, and any intrusion into the cyber networks of another country is prohibited by sovereignty. So do you all see the differences in the positions? Now, let's see what these positions actually look like. This is the UK position. This is a direct excerpt from the UK position. So look at the highlighted text. The general concept of sovereignty does not provide a sufficient or clear basis for extrapolating a specific rule of sovereignty. That's the UK position. And notice, we're not talking about just cyber. This is a general doctrinal position. This is the position of countries. These are examples of the positions of countries from that middle box. Okay? So let's look at Denmark. Denmark says sovereignty is a primary rule. All right? So you can immediately see the difference between them, right? The UK says not a rule, not a primary rule. Denmark says it is a primary rule, but look at the details. It says that only a cyber operation that causes, you see here, physical damage or injury would constitute a violation of sovereignty. And in addition to physical damage or injury, you have what is called loss of functionality, depending on nature, scale, and effects. What's loss of functionality? Let's simplify it. It doesn't have to be technical. Can you imagine, what is a loss of functionality? What does that mean? Yeah, but disable. Can you give me an example of disable? What does that look like? Like practically, what does it look like?
It means that, for example, if it is a machine, it won't work anymore.
Yes. You can't access your email, for instance. Sorry? Airports. So for example, if you shut down air traffic control, nothing is physically damaged yet. I mean, an airport is very dangerous, but let's just stick to email for an hour. But if you have a digital system that is supposed to function in a particular way, but then it loses its functionality. But even then, Denmark tells you, depending on nature, scale, and effects, which means a small loss of functionality, maybe not a problem. Maybe not a problem. But a big loss of functionality, maybe a big problem. Okay? And then look at this. Cyber activities causing negligible physical effects or loss of functionality would generally not be considered a violation of sovereignty. Again, what I need you to do is to think on two levels. Think of the importance of cyberspace to everything you do in your lives, but also think about the broader implications. This is not just about sovereignty in cyberspace. It's about the concept of sovereignty. And again, the implications are huge. Let's look at New Zealand. Because I think New Zealand were very forthcoming in their views. They basically said, there are a range of circumstances in addition to pure espionage in which an unauthorized cyber intrusion, including if it causes effects, would not be wrongful. So basically, New Zealand is telling you spying is lawful. You don't like that? Oh, sorry. No, okay. Maybe New Zealand. But anyway, we're on YouTube. Again, here's the nature of the debate, right? These are the implications. And what I want to go back to, we really got to move on because we're running out of time, is that this debate is also very important on a policy level, but it's also a deep doctrinal debate. Sovereignty, like our friend from Tokyo University mentioned, was defined, for example, in the Island of Palmas case by the arbitrator Max Huber. He equated sovereignty to independence and defined independence as the right to exercise the functions of a state to the exclusion of all other states. But some people would tell you that defining sovereignty in terms of independence doesn't really take us very far. Doesn't take us very far, especially that in today's world, there's virtually no country that is actually, in reality, totally independent. There's no such thing. The level of interdependence is so deep that the whole concept of independence needs to be rethought. The third box, remember there are 3 boxes, is the position, as an example, of the African Union. So the African Union tells you, look, in international law, we have plenty of judicial precedent that affirms that sovereignty is a rule of international law. It includes the SS Lotus case, the Island of Palmas case, the Corfu Channel case, the Nicaragua case from 1986, Nicaragua versus Costa Rica, and so on and so forth. So we have a lot of judicial precedent that supports the proposition that you find here, that under international law, states have an obligation to respect the territorial sovereignty of states, and the African Union says this is a primary rule of international law. And on that basis, the African Union says any unauthorized access into the ICT, so ICT is information communication technology, the ICT infrastructure located on a foreign state's territory is unlawful. So the African Union took the position sovereignty, understood as territorial sovereignty, applies in cyberspace just like it applies in the physical world and prohibits any unauthorized intrusion. And then we went a step further and we said, this rule does not include a de minimis threshold. Remember what I said earlier, that some states say sovereignty is a rule, but there's a threshold. The African Union said, no, we don't agree. And the reason we said that is partially based on legal methodology. In the SS Lotus case, the Permanent Court of International Justice basically said the following, that unless there is a permissive rule that emerges, the protections of sovereignty are absolute. Let me read it to you instead of trying to rephrase it. The first and foremost restriction imposed upon a state by international law is failing the existence of a permissive rule, right? Failing the existence of a permissive rule, which means unless you have a rule that permits the conduct, a state may not exercise power in any form on the territory of another state. And the view of the African Union was, we do not have a permissive rule. Why? Because we do not have sufficient practice, we do not have sufficient expressions of opinio juris to create an exception to the obligation to protect territorial sovereignty of states. I'm going to move on, but again, what I want you to take away is the following. I don't want you to leave this room thinking that there are definite correct answers. I need you to take away that this is a hugely important debate, that is changing all of international law. I think this position is correct, partially because we wrote it together. But that's not important. What I think or what Africa thinks, that's not important. What's important is for you to understand the importance of the debate and to understand its doctrinal implications, for you to understand how to operate with the rules, how to use precedent in order to support your argument, how to construct a position on the basis of material that you already have, whether in treaties or practice or opinio juris. That's what I want you to take away. I think all of these 3 positions make sense in a certain way. The UK position is founded on a long-standing doctrinal debate and a doctrinal controversy on the nature of sovereignty. The position in the middle is an attempt to come up with a creative solution to the challenges of cyberspace. The African Union position is a traditional, doctrinally solid position that reflects how international law was 100 years ago. But you can still say, maybe this position doesn't reflect the realities of cyber. So again, what I need you to take is, this debate is important, and also to learn how to operate with the rules. All right, moving on. Non-intervention. Again, the big question here is, how do you define coercion? Remember the cases we talked about earlier? Some of you, almost everyone was saying, if Gondor asks Rohan to vote in a particular way in the General Assembly of the UN, everybody was like, that's okay. And everybody was like, you know, taking a position on a referendum or an election might be unlawful under the Vienna Convention. And then we were unsure about misinformation and disinformation and deep fakes. The core of this debate is, what is the meaning of coercion? All right? So let me ask you all, what is the meaning of coercion? Where? Yes. Okay, wait, you said pressure and violence.
Or not every pressure causes violence. So, we can say it interchangeably.
All right, so this individual here, if I'm sort of towering over him and leaning against him, is this coercive? Is this pressure?
It's pressure.
It is pressure. So if I tell him, hi. If I tell him, hand me over all the money. Do you have enough money in your wallet? Okay, not much. That's not worth it. If I say, turn over all the money in your wallet right now, and I'm just doing this, is he going to give me all the money in his pocket? What do you think? What's that? He can take it. He can take it. He's a big guy. He can take it. Now, let's assume I take a gun out of, I don't have a gun, don't call the police. But let's assume I take a weapon out of my pocket and aim it at his head. Give me the money. My question to you is this. Where is the line between persuasion and coercion? I can try to persuade him. Think of, you know what I said earlier about the UN vote? That's persuasion. That is Ambassador Mikanagi-san calling and saying, Hiraro-san, we have great bilateral relations. Egypt and Japan have been friends for over a century. We would really appreciate if you vote. How many times have you made that call? It's part of your business. It's part of everybody here who's a diplomat does that all the time. It's called a démarche even. Right? There's even a fancy name for it. What you're trying to do is to persuade. Now, let's assume, because Japan would never do this, but let's assume that you have a hypothetical country that goes up to another country and points a gun. Is that persuasion? Okay, what about, instead of actually pointing a gun, sending an aircraft carrier in the area, just sailing around? What is that? And then when you say, why do you send that aircraft carrier there? What would be the response? What would be the response? The reason I ask, because you're landlocked, so you're not going to have to worry about it. What would be the response of the country that has the aircraft carrier?
You're asking the response of a country that would have sent an aircraft.
Exactly. So I'm the country where there's an aircraft carrier 30 nautical miles. So it's not in the contiguous zone, not in the territorial waters, and it's just sitting there or moving around back and forth. And I'm like, I don't feel comfortable. How would you respond?
Definitely. In the line of defense, they would tell you they are not violating any international law. So
freedom of navigation. It's an exercise. Again, the challenge here is, how do you define coercion? At what point does a disinformation campaign or a statement by the foreign ministry or dispatching an aircraft carrier cross the line between permissible conduct and coercive conduct? If you can figure that out, I will give you 5,000 yens, right? Because it's a very hard question. It's a very, very hard question. There's no definitive answer. But so basically, in this debate in cyberspace, countries and parties have generally agreed that the prohibition on intervention, which, by the way, is a purely customary international law rule, it is not codified in any universal treaty. It is codified in certain regional treaties and in bilateral treaties, like Articles 19 and 20 of the Bogota Charter of the Organization of American States. It's in the African Union Charter. The Constitutive Act of the African Union. It appears there. And it also appears in documents like the 1970 Friendly Relations Declaration or the 1965 Declaration of Non-Intervention. So it's out there in many different sources. But we're not sure what exactly is the content of this rule, right? We don't know at what point is the line crossed. In this debate on cyber, there is general agreement that non-intervention consists of two constitutive elements. The first is the domaine réservé, which basically, well, in English, it's the reserved domain, which is, anyway, I won't make jokes about French. The reserved domain is the first element. The second element is coercion. And you see here, these are just two examples of two countries, and they define the two elements the same. So Germany says non-intervention is interference with the domaine réservé and coercion. Italy, very similar. It says when a state employs coercive means in matters under the domaine réservé. So everybody agrees on the elements, okay? The challenge is defining the elements. So the domaine réservé is basically understood as areas of state policy that are reserved to the state by virtue of the S word that we have just failed to define definitively. Look at it. The reserved domain is, see this? Intervention in internal or external affairs of another state in matters over which, in accordance with sovereignty, states have exclusive authority. Again, we're using a concept on which there's no universally accepted definition, namely sovereignty, to define one of the elements of non-intervention. So what many countries have done is this. They found a practical solution. Instead of trying to come up with a definitive juridical definition of domaine réservé, they provided examples. Examples. So countries here are saying, so for example, the Netherlands are saying national elections is an example of the domaine réservé. Or recognition of states. I think you said recognition as part of your definition of sovereignty, right? So the Netherlands is saying whether or not we, as the Kingdom of the Netherlands, recognize a state as part of our domaine réservé. And then they're saying membership of international organizations. Remember the hypothetical about Gondor Brexit? I didn't mean that. Gondor exit? So the Netherlands is saying, if you try to intervene in our choice of membership in an organization, that's in our domaine réservé. Again, Norway, look at Norway. Altering election results. Question, do you see a difference, just on elections, do you see a difference between Norway and the Netherlands? The reason is I need your name. This is not your name. Well, today you are Narij. Too bad.
Because both of them gave similar examples, like the elections.
Yes, but look at the details. Yes, go ahead. My sister, Laureen? Laureen, excellent. The best food is from Kenya.
Sorry?
Are you from Kenya, right?
Yes.
The best food is from Kenya.
Oh, really?
I love Kenya.
Thanks.
Good. And also Uganda's great, because we're going to create a problem here.
And Tanzania also. So
This is like if you go to West Africa, never have a conversation about jollof rice. Never touch that, right? Well, you're from Djibouti, so you're fine. You're on the other side. Yes, go ahead.
So the big difference I see here is the word manipulation.
Yes. So look at, first, the Netherlands is very general.
Yes.
They're like national elections. They don't really tell you how. Norway says altering the results. Altering the results is a very intrusive act. But then they also say manipulating election systems, which means you go to the ballot box, you put in your vote, and then somebody hacks the system and changes the results. So that's one form. They also say unduly influencing public opinion by disseminating confidential information, hack and leak.
But, okay, what I appreciate about the definition by Norway is that despite them using so many words, the intention is just to say the manipulation with the intention of like eliciting negative externalities, like a reaction, negative reaction.
Yes,
Yeah.
yes. So what you see here is that different countries are providing different examples, but more importantly, the different examples indicate different levels of intrusiveness. All right? So Norway gives you more detail. And in the process, it gives you a better sense of, sorry, I'm going to beat you up again, of how much pressure, right? Think about it this way. Altering the result is a lot of pressure because you're literally changing the content of the ballot box. But unduly influencing public opinion is like me sitting here. You have to vote for that candidate. If you don't vote, you're going to be in trouble. You really have to vote. You see what I'm saying? Unduly influencing public opinion. And in the context of cyberspace, that's done partially through social media, through chatbots, through misinformation, through spreading rumors and lies, and so on and so forth. So that's what Norway is saying. Singapore and Poland, again, give you more examples. Singapore, as you can see, is similar to the Netherlands. Singapore just says, electoral process, if you interfere with the process, including by cyber attacks against infrastructure. It's very broad, doesn't give you too many details. But Poland provides you a lot more details. It tells you, look, adversely affects functioning of political and security, political, economic, social system. And then it gives you examples. For any action that would prevent the filing of tax returns online. So I live in the US where everything is, you file your taxes through online systems. You fill in the forms, you set send, it goes to the IRS. They say, we've approved your return. Here is the refund you get from the state and from the federal government and maybe from the city. Everything's online. According to Poland, if you disrupt that system, that's unlawful. Look at this. Wide-scale and targeted disinformation campaign. So anyway, the conclusion here is this. We don't have international consensus on the meaning of domaine réservé. But what you're seeing is a debate, a super important debate in which the elements of these foundational rules are being reimagined. Remember, most people go to law school and they think that the rules like intervention. They think it's like such a simple rule, it's been around forever. It's not. It is being renegotiated as we go. Coercion. Coercion is even more complicated, right? You have, again, three approaches. Some countries, like the UK and Canada, Australia, New Zealand, Costa Rica, and Brazil, they define coercion as deprivation of free choice. Other countries, Switzerland, Poland, Denmark, Netherlands, say it is causing a state to act or refrain from acting involuntarily. Why is this important? Go back to these positions. What this tells you is that the intensity of the interference has to reach a level at which it causes a country to act involuntarily. In other words, it's not enough to have, for example, a disinformation campaign which makes you uncomfortable or that is inconvenient. It has to rise to a level that causes the state to act involuntarily. So that's a relatively high threshold. Same thing with deprivation of freedom of choice, where you're basically denying the country its ability to exercise choice. Deprivation of free choice. The African Union and Thailand have adopted a relatively lower threshold, and I'm going to move here a little faster because we're running out of time. So for example, look at Thailand and the African Union. So the African Union says it is not necessary for an act to be coercive. It's not necessary for it to rise to the level of completely depriving freedom of choice or to compel a state to act involuntarily. Look at Thailand. Thailand says coercion may arise where a cyber operation undermines sovereign functions. So this part is another way of saying domaine réservé. It undermines sovereign functions, but then it says impairs ability. Guys, we're lawyers. The most important thing we do is we play with words, right? Look at the difference between involuntary or depriving free choice and impair. Impair denotes a notably or markedly lower threshold of pressure, right? So impairs its ability to exercise the domaine réservé freely, and look at this, even without a demand or a motive or an intent. So Thailand and the African Union adopt a relatively lower threshold of pressure. Again, try to simplify these concepts. Every time, so forever, you're going to be associated with intervention. When all of these colleagues go back to their capitals, whenever they think of intervention, they're going to think of me bullying you. And you ask yourself this: how much pressure is coercive? And what you're seeing here is multiple answers to that question. All right, I have 3 minutes to do the use of force, so that's obviously not going to work. But let me summarize the debate. The debate is the definition of force. Since 1945, when the UN Charter was negotiated, force was understood and defined as damage or destruction of physical things, tangible things. It has to have a tangible effect. And notice what I'm saying here, it's tangible effect. Why is this important? So, sorry, I'm going to shoot you now. So, what we're looking at is physical effects, not necessarily the physical nature of the weapon. So important. So if I shoot my friend here, no, this is not, money is not going to help you. He's like, can I give you some money? I'm like, sorry, we're not negotiating, buddy. So if I shoot him, that's a use of force because it's causing a physical effect. But think of chemical, biological, or bacteriological weapons. There's no physical manifestation, but the effects are physical. So the definition of the use of force has generally been understood as causing physical damage using any kind of weapon. The kind of weapon doesn't matter. What matters are the effects. So the effects are physical, right? Now look at this. Look at the Netherlands. Purely economic, diplomatic pressure or coercion is not defined as force under Article 2, Paragraph 4. Okay? This is reflective of the classical position. The African Union has the same view. An attack would be a use of force if scale and effects of the operation are comparable to those of conventional acts of violence. We're talking about physical effects. Now, look at this. Norway and France are suggesting that certain forms of massive economic loss could be a use of force. Loss of, like, economic effects, loss of money. Look at it. A use of cryptoviruses and other forms of digital sabotage against financial and banking systems that cause widespread economic effects and destabilization could amount to a use of force under Article 2, Paragraph 4. This is huge. What we are seeing is a proposal. I would categorize this as a proposal de lege ferenda. It's a proposal to change the law. And again, because I'm running out of time, I leave you with where I started. This debate is so important. So important. This is not some techie debate. Who said that he's not into IT? Somewhere there, my friend. Right. So my friend there was saying, I'm not into IT. Yes. But what I'm telling you is this debate is so fundamental to the structure and core components of international law. It's not some niche technical debate. It goes to the core substance and fundamental tenets of international law. Yes? How's my Japanese?
Thank you, Professor.
I can tell you, Google is perfect.
I want to know whether you have anything to say about United States of America regarding non-intervention or coercion.
That's the question?
Yes.
I have a lot to say.
So, you should discuss.
Right now?
Not now, but before the audience.
Is there a specific question? Because there's much to say.
I want to know something, whatever you have discussed, and regarding non-intervention, you have discussed much about some countries. For those countries, this world has no problem. But there are some countries, I think most of us should have some belief that there are some countries for whose step this world face some difficulties, and also international law face some debate, some criticism.
Okay, so I mean, your question. I mean, I'm 3 minutes over time, and I'm gonna, they're gonna get fired if I go over time. Look, there are policy elements to your question. There are historical elements to your question, and we can debate that for hours. That's first. Second, I think all states have engaged in one way or form in conduct that you're probably thinking about. That's second. So it's not really unique to the United States, but the difference is the United States is a superpower, and so it has a much broader impact. But I think what is important to this conversation is the United States. Look at I think they're either 3 or 4. The 3 or 4 times, I think the latest was 21 and 2020, the multiple times in which the United States has expressed publicly its position on international law and cyberspace, the United States does not question or challenge the validity of the prohibition on intervention. The United States is a party to the OAS Charter of 1948. The OAS Charter, which includes Article 19 and 20, which have the clearest expression of the prohibition on intervention. So what I would note is the United States does not challenge these rules at all. They've engaged in the conversation. Now, if you have comments or thoughts about US policy, or really the policy of any country, we can talk about, we're out of time, so we can talk about that in the coffee break. But what is, I think, important is that this debate is perhaps the first time in decades where countries are expressing their views on the details. Nowhere in the past, I'm just going to, and I know I'm out of time, nowhere in the past, so people think the prohibition on intervention, it's been around for a long time, and of course it has. Nowhere have countries provided this much detail on the content of the rule. And that's why, again, this conversation is important, right? Because it offers countries the opportunity to at least develop the rules in a particular way that would provide them with protection that they feel they need. All right? Arigatou gozaimasu. All right.
Thank you very much.